Hi everyone, my name is Chelsea Lee Hankey and I'm an elder law attorney here at Archer Law Office. Today I want to talk to you a little bit about something called a guardianship. So people often come to us and they want to be able to help out their parents. They come in and they say something like, how can I get the power to help mom and dad with their finances? Or if mom goes to a doctor's appointment and I can't go with her, how do I get the power to call to be able to get that HIPAA protected medical information from the doctor's office? So there are a few different ways you could go about it. Very briefly, the easiest way is for mom or dad to execute either a power of attorney or a healthcare proxy document to give you those powers so that you can access both financial and healthcare information on behalf of your loved one. However, for certain people, if they don't have those documents already, or if there's a problem with those documents, you might not have the option if your loved one no longer has the capacity to execute those documents. So what do you do if you're in that situation? This is when something called a guardianship comes into play. So what is a guardianship? A guardianship is a legal proceeding where an attorney will prepare pleadings on behalf of the family, and the pleadings are filed with the superior court in the county where you live. The court is looking for information about the individual that you're seeking to get guardianship of. They want to know about their assets, and they also want to have two doctors confirm that this individual lacks the ability to make decisions for themselves. Once that paperwork is filed, the court will appoint someone called a court-appointed attorney to represent your loved one. The job of this attorney is to come and visit with your loved one and talk with other family members to really get a good picture of what your loved one's life looks like. Once the court-appointed attorney has done that, he or she will write a report and make a recommendation to the judge as to either one, this person does have the capacity to manage their own affairs, or two, they lack the ability and they need someone to help them with that. Once that happens, there's going to be a hearing before the judge who wants to hear evidence and pretty much just hear the story of what's been going on. At that time, the judge will then make a ruling as to whether the individual is capacitated or incapacitated. And if they're incapacitated, the judge will select another individual, most often a family member, to act on that person's behalf. Once you have a guardian, the most common powers that are granted with a guardianship are the guardian of the property and guardian of the person. Those are just fancy words. All they mean is that the guardian has the ability to make financial decisions on behalf of their loved one, and they also can make medical decisions and decisions about where that person lives. The job of the guardian is not to make judgments based on what they think is best, but to put themselves into the shoes of their loved ones and make decisions that are in the best interest of that individual. So if you're in a situation where you do not have proper documents such as a power of attorney or a healthcare proxy, and your loved one is not in a position to be able to execute those, a guardianship might be a very good choice to help you. On behalf of Archer Law Office, we want to thank you for watching these videos. If you have any questions about anything that you've heard here, feel free to call us at 609-842-9200. Thank you.